the procedural requirements for an employer dealing with mental health in the workplace? I think that this question is going to be considered far more regularly due to the continuous effects of COVID-19 and the increasing mental challenges that so many individuals are currently facing. In terms of the Labour Relations Act, an employer is prohibited from dismissing an individual who's suffering from mental illness unless the employer can prove two things. Firstly, that the employee's mental illness has incapacitated the employee to perform on a permanent basis or for a continued period of time. And secondly, that the employer has followed a statutory incapacity procedure and has been unable to find an alternative short of dismissal. In these instances, employers must be guided by items 10 and 11 of the Code of Good Practice on Dismissal. In terms of this code, employers are required to conduct a proper investigation into the mental illness and the incapacity of the employee. For example, the employer must determine what is the cause of the employee's incapacity. Particular consideration must be given where the cause of an individual's incapacity is due to a work-related stressor. If this is the case, the employer has a far greater obligation to accommodate this employee and try and find alternatives where the reason is actually as a result of the employee's work-related stressor or from a hot-headed manager. In addition, employers must look at what is the extent of the individual's incapacity. Is this a permanent basis? Is it a temporary basis? How long are you going to be dealing with this individual who is unable to perform? And then lastly, you need to look at exploring alternatives short of dismissal. So where the individual's depression or incapacity is going to impair their ability to perform on a permanent basis, then the employer needs to consider what reasonable accommodation it can possibly offer to try and assist the employee as much as possible. When an employer fails to conduct a proper investigation into an individual's mental illness or incapacity and dismisses the employee, that dismissal is likely to be found unfair. The onus therefore rests on the employer to prove that the employee is in fact incapacitated and cannot work on a permanent basis, and that the employer has considered all alternatives short of dismissal in order to establish that the dismissal is substantively and procedurally fair. This is why I think it's so important for employers to understand and be aware of the implications of mental illness in the workplace in order to be able to address these issues appropriately and in line with the law. In the next episode, we're going to deal with instances where mental illness manifests itself in poor performance in the workplace and how an employer must conduct itself and deal with these issues adequately.